Hey everyone, welcome to this explainer. Today we're unpacking a deeply complex and honestly highly publicized legal controversy that has completely gripped the nation. It's really sparking intense debate about the very nature of our justice system. We're looking at the Fordingbridge Rape Case. This is a situation that has literally left people stunned, asking some really fundamental questions about how the law handles severe crimes when they're committed by very young offenders. So, our goal today? To strip away all the noise. We're going to look at the facts, the timelines, and the legal frameworks to understand exactly what happened, why the judge ruled the way he did, and what actually happens next. Okay, let's dive into this by anchoring ourselves right in the emotional reality of the courtroom. When the sentencing was finally handed down, one of the victims, who spoke anonymously to the BBC alongside her family, described the decision with this incredibly powerful sentiment. She said it was like a rock straight in my face. She articulated this profound sense of shock, expressing that the ruling almost made her feel as though the severe crimes committed against her were somehow deemed acceptable in the eyes of the law simply because of the perpetrator's ages. This shared disbelief is really the emotional core of the controversy we're examining today. To understand that shock, we really have to look at the factual baseline of the legal decision because it presents a striking contradiction. Two teenage boys walked out of court with a combined total of 10 rape convictions between them. 10. Yet neither was sentenced to custody. Instead, they were given youth rehabilitation orders. These are community-based sentences focused on supervision rather than actual jail time. And this specific outcome, the sheer volume and severity of the convictions paired with a non-custodial sentence, well, that's the exact flashpoint that sparked all the national headlines and widespread outrage.
Part 1. The Crimes and Convictions. So to truly grasp how we arrived at this highly debated sentence, we need to go back to the beginning. Let's trace the timeline of these harrowing events in Fordingbridge, Hampshire. The first incident happened in November 2024, and that involved a 15-year-old victim. Just a few months later, in January 2025, a second attack took place, this time involving a 14-year-old victim. Now, the perpetrators were incredibly young themselves. We're talking about two 14-year-old boys who were involved in both incidents, and a 13-year-old boy who was also convicted for his involvement in that second attack. Following these events, the boys denied the charges, but they were ultimately found guilty after a trial at Southampton Crown Court in March 2025.
The details of these crimes, as presented by the Crown Prosecution Service, are, quite frankly, deeply distressing. In both instances, the young girls were significantly outnumbered by the boys and subjected to these prolonged ordeals. The first victim was pressured into having sex in an underpass by the River Avon, absolutely terrified she'd be thrown into the water if she didn't comply. Then, the second victim was attacked in a field near the Fordingbridge Recreation Ground, where one of the defendants actually used a knife to cut her clothing. And crucially, prosecutors revealed that the boys filmed these brutal attacks on their phones. They even captured footage of one victim lying motionless, and then actually went ahead and shared some of this footage online.
Part 2. The judge's legal rationale. Now, given the extreme severity of everything we just talked about, the immediate question is, how on earth did this result in a non-custodial sentence? Well, it brilliantly illustrates the incredibly difficult balance the judge was legally required to strike. On one side, we have the severe aggravating factors, right? The prolonged nature of the attacks, the fact that they were filmed and shared, and the use of a weapon. And the judge explicitly stressed the seriousness of these crimes, noting that the filming made them even worse. But weighing against all of that are the legal mitigations tied to how the justice system approaches youth. The judge emphasized their very young ages, just 13 and 14. He stated he had a legal obligation to avoid criminalizing children unnecessarily, to help them understand the effects of their behavior, and ultimately to support their eventual reintegration into society.
This incredibly complex weighing of factors culminated in Judge Rowland's final decision, which is perfectly encapsulated in this stark quote: "None of you need to go to prison today." When those words were spoken in the courtroom, the contrast in reactions was absolute. Two of the defendants' mothers immediately burst into tears of relief. But meanwhile, as we heard earlier, the victims and their families were left utterly devastated by a ruling they felt completely invalidated their suffering. Part 3. Public and political outcry. And that localized devastation in the courtroom? It certainly didn't stay there. It immediately spilled over, causing a backlash that was swift, massive, and reached the absolute highest levels of government. Prime Minister Sir Keir Starmer actually addressed the case during a visit to East Sussex, praising the courage of the victims. He offered this dual perspective, stating that he found the case distressing both as a politician and as a father. Significantly, the Prime Minister's intervention confirmed that there were serious questions about the sentence. really signaling that the government was acutely aware of the public's total disbelief.
This exact sentiment was echoed and actually expanded upon by the Attorney General, Lord Hermer. He didn't just speak about the Fordingbridge case in isolation. Instead, he explicitly linked it to a broader national context, stating unequivocally that there is an epidemic of violence against women and girls in this country. He promised swift action to review the decision, emphasizing that the government wants to ensure women and girls have confidence in the justice system and, of course, to bring closure to the victims. But the outrage didn't even stop at the UK border. The shock resonated internationally. French rape survivor and advocate Giselle Pellico, speaking right after headlining the Hay Festival in Wales, voiced her profound dismay. She stated she was deeply shocked that the perpetrators were able to gain their freedom while the victims just continue to suffer. Her voice added a really powerful, globally recognized perspective to the sheer courage that was required by these young victims to even come forward.
Yet, amidst all these high-profile voices, the most vital perspective remains that of the victim's family. In a statement to the BBC, they outlined their clear demands. They are hoping for a punitive sentence that actually fits the crime, with no excuses, and most poignantly, they emphasize that their fight isn't just for their child, but to ensure this leniency doesn't deter other victims from coming forward in the future. They're really holding out hope that due justice will be served.
Part 4. How sentence appeals work.
So the crucial point is, what actually happens now? How does a sentence like this even get challenged? Well, first, it's really important to demystify a key constraint of the justice system, and that's the silence of the judge. You might be wondering why Judge Rolland isn't on the news defending his decision amidst this massive public storm. It simply comes down to protocol. Judges never publicly comment on cases they oversee outside of the courtroom. Doing so could potentially undermine the official words and the legal reasoning they provided during the trial. Their ruling absolutely must stand on the court record alone.
Because the judge cannot alter or defend the sentence post-trial, a very specific procedural path has to be taken. First, anyone can complain that a sentence is unduly lenient, and that complaint goes straight to the Attorney General. Next, top prosecutors are brought in to advise. They'll analyze if the sentence is completely at odds with comparable cases, making sure to take into account the legal discretion judges are actually allowed. Finally, if the Attorney General concludes the sentence was indeed out of line, it gets referred to the Court of Appeal. There, a panel of 3 senior judges will hold a public hearing to definitively rule on whether the original sentence was right or if it was, in fact, unduly lenient. As this case makes its way to the Court of Appeal, it leaves us grappling with a massive and perhaps unanswerable dilemma. How can the justice system ever perfectly balance the legal mandate to rehabilitate child offenders with a victim's profound, justified need for punitive closure? It's a friction point where legal theory collides painfully with real human trauma. Thank you so much for joining me to walk through the facts of this incredibly challenging explainer. Keep an eye on the news for the Court of Appeal's impending decision because it will surely be a landmark moment for the justice system.